Be ready and start. It is right that the courts and tribunals having plenary jurisdiction have discretionary power to grant an appropriate relief to the parties stop. The aim and object of the Industrial Disputes Act may be to impart social justice to the workman, but the same by itself would not mean that, irrespective of his conduct, a workman would automatically be entitled to relief. Stop. The procedural laws like estoppel, waiver, and acquiescence are equally applicable to the industrial proceedings. Stop. A person in certain situation may even be held to be bound by the doctrine of substantial stop. The respondent herein did not raise any industrial disputes questioning the termination of her services within a reasonable time stop. She even accepted an alternative employment and has been continuing therein from 10/8/1988 stop. In her replication filed before the presiding officer of the Labour Court while traversing the plea raised by the appellant herein, it was averred that she is gainfully employed with effect from 10/8/1988 and her services be regularized. Stop. It is true that the respondent had filed a writ petition within a period of 3 years, but indisputably the same was filed only after the other workmen obtained same relief from the Labour Court in a reference made in that behalf by the state stop. Evidently, in the writ petition, she was not a position to establish her legal right so as to obtain a writ of mandamus directing the appellant herein to reinstate her in service stop. She was advised to withdraw the writ petition, presumably because she would not have obtained any relief in the said proceeding stop. Even the High Court could have dismissed the writ petition on the ground of delay or could have otherwise refused to exercise its discretionary jurisdiction stop. The conduct of the appellant in approaching the Labour Court after more than 7 years had therefore been considered to be a relevant factor by the Labour Court for refusing to grant any relief to her stop. Such a consideration on the part of the Labour Court cannot be said to be an irrelevant stop. The Labour Court in the aforementioned situation cannot be said to have exercised its discretionary jurisdiction injudiciously, arbitrarily, and capriciously, warranting interference at the hands of the High Court in exercise of its discretionary jurisdiction under Article 226 of the Constitution. Stop. Next stanza. It is also relevant to note that there may or may not be any regular vacancy with the appellant bank stop. We have noticed herein before that in the year 1996 the vacancies had been filed up and a third party right had been created stop. It has not been pointed out to us that there exists a vacancy stop. Having considered the equities between the parties, we are of the opinion that it was not a fit case where the High Court should have interfered with the discretionary jurisdiction exercised by the Labour Court. Stop. For the reasons aforementioned, the impugned judgment cannot be sustained, which is set aside accordingly. Stop. This appeal is allowed. Stop. However, in the facts and circumstances of the case, there shall be no order as to costs. Stop and over. अगर आपको कोई भी वर्ड डिफ़िकल्ट लगे, उसकी आउटलाइन के लिए या किसी भी तरह की कन्फ्यूज़न के लिए आप नीचे कमेंट करें। थैंक यू।